All rise. The Court of Appeals Division 1 is now in session.
Please be seated. We're here today in our case 1CA CV18-0350, Mendoza v. State. Each side will have 20 minutes to argue. Appellant, you may save as much time as you want for a rebuttal, but you'll have to keep track of the time yourself with a clock at the podium for that purpose. We are recording the argument both in audio and video. The argument will be up on YouTube in a couple of days if you want to watch it. So when you come forward to argue, please identify your client and yourself so we can keep everything straight when we consider the recording. We've conferenced the case, we've read the briefs, we've examined the record, so we're familiar with the case. So when you begin your argument, just launch right into the topics that you want to discuss with us. Appellant, you may begin.
Thank you, Judge. May it please the court and counsel, my name is John Leader. I represent the plaintiff, the appellant Marianne Mendoza. Her adult son, Brandon Mendoza, who was an off-duty Mesa police officer, died in May of 2014 in a wrong-way crash, as the court knows. The trial court erred in granting summary judgment in favor of the state. This court reviews these issues de novo, and any factual issues are reviewed in a light most favorable to Ms. Mendoza, as the court knows. In this appeal, although we initially addressed issues related to both ADOT and DPS, we are now dealing only with ADOT issues as reflected in our reply brief. The trial court erred first. So what the trial court did, the court excluded our experts and then based on the exclusion, granted summary judgment. And the exclusion was legal error. Our first expert was Dr. Robert Blyle, who in the Glazer case, this very court ruled was qualified to give expert opinions in transportation cases against the state.
Counsel, was that the holding that Blyle is licensed effectively to opine upon all areas of traffic design, or was that a specific claim with a specific methodology about barriers?
What Glazer says on that issue, Judge Weinsweg, is that the trial court shouldn't select the specific area of subspecialization. For example, in Glazer, the state argued that Blyle wasn't qualified because he had never designed a road. And this court correctly ruled that you don't look at the issue that narrowly. The issue is more broad. It's a liberal review, and it's a broad review. And is the witness qualified from a big picture standpoint to give opinions in the general areas involved? And that would be transportation engineering and traffic engineering. And this is discussed in the Glazer opinion. So to answer the court's question, yes, I believe that the Glazer decision is an endorsement, a general endorsement of Dr. Blyle for any transportation engineering issue within his expertise against the state. And I think the trial court erred in...
Counsel, do we consider instances in which, first of all, has Dr. Blyle's testimony, in your knowledge, ever been excluded?
Not besides this case.
Okay. And so Sentite, I guess, it was something with different facts?
The Sentite case, Judge, to be honest with you, I'm not familiar with it. And if it would be pertinent to address it through supplemental briefing, I can, but... I
guess the larger question is, taking this what would be a point of law, which is some sort of almost preclusionary effect, that you're certified at one time by one panel of the Court of Appeals, and you are thus qualified to opine in all of these areas. do we as a panel also look at cases that might have excluded that witness? How far does this go?
Well, again, I think it's a big picture analysis, and I don't think that the court needs to accept our interpretation of Glazer in order to conclude, which the court should, that the trial court erred. The McMurtry case versus the Weatherford Hotel was the first case post the 702 amendment when Daubert was applied and adopted. And it says it's a big picture, experience-based in many cases analysis. In McMurtry, the trial court excluded the plaintiff's expert who was, his only qualifications were 40 or 50 years of expertise. And this court ruled that was error. Again, it's a liberal approach. It's very broad. The primary method for attacking issues like that is cross-examination in the adversary system. Glazer says that. McMurtry says that. So we don't, I believe this court has held, we don't want to kind of fly-spec experts and accept arguments like Blyle's never designed a road. Blyle's never been involved in a wrong-way case. Because if you do that, if you let that become the question, then it's going to be really difficult for plaintiffs to have experts who can offer appropriate testimony. Because you're not always going to find an expert who has hyper-specific experience similar to that in that case, and there's no Arizona common law or rules or statutory law that requires that. Again, if you look at Glazer and McMurtry, it's a big picture approach. Does the expert generally have the qualifications necessary that will help the jury? And Dr. Blyle's experience and qualifications are extensively discussed in Glazer. He worked for the Utah Department of Transportation for several years in a high-ranking position, which would ideally suit him to offer opinions about what a transportation department should do when it addresses a big-picture problem like this.
But the question whether Dr. Blyle is qualified, it seems to me, in first instance, is a determination for the trial judge to make.
It is.
Not just because we three sitting here in another case said that the trial court in another case should have accepted Dr. Blyle as an expert, correct?
Yes and no. So it's an abuse of discretion, but this court reviews de novo the court's application of law. And the law that the trial court erred in applying is the McMurtry case and the Glazer case. And you don't, again, the trial court ruled because Dr. Blyle didn't have specific wrong-way experience, he's not qualified. And she also addressed the standard of care, which I hope to address later. But McMurtry and Glazer are clear that you can't look at it that narrowly. And these are issues the court would review de novo. The law that applies, that's a question for this court de novo. And then applying that law, it is true, it would be an abuse of discretion standard. But if you look at McMurtry and Glazer, I think that the trial court's decision excluding Blyle simply cannot be squared with those cases if you look at his extensive experience. The law favors allowing these types of experts to testify. And if the trial court's ruling were upheld on qualifications, it would severely limit not only plaintiffs but defendants in these cases to come up with experts qualified to help juries. And juries do need help in these cases. These are issues, that's an issue in this case, is whether Dr. Blyle's testimony would have helped the jury. And the trial court ruled it wouldn't. And
well, counsel, let's talk about, I guess we can break it down into standard of care and breach. And so the argument, at least, is that on that first half, Blyle refused to commit to a finite universe or description of a standard of care, and sort of said, these brainstorming. These are things that could be done that might work or might not, and that is a reason to exclude the testimony. What is your position on that?
My response is that Dr. Blyle didn't say they might not work. In fact, he said it's probable that they would have worked. And the best example I can give, Your Honor, is take the Katrina disaster. And what if FEMA had come in and done nothing? They do nothing in response to the disaster. Everybody would agree that that's improper and that's negligent. And there's a host of things they could have done. And then the issue is, if they had done a certain combination of things, would it have prevented deaths? So it becomes a causation question.
Well, and we can move to that second part then as well. I thought that the argument is that Blyle doesn't know.
Well, and I'll address that. And Judge, this was in my supplemental authorities. A plaintiff in a case against a governmental entity is not required to prove a standard of care. And it's in my April 10th of 19 supplemental authorities. The state's duty is one of reasonableness, and the question is whether the state acted reasonably, and from day one, the opinions we disclosed for Dr. Blyle was that the state did not act reasonably. The supplemental authorities that we cited clearly hold that the reasonable person standard applies in almost all cases, and there is no case law requiring a standard of care or requiring a standard of care to be proven in cases like this. It's something for a medical negligence case, where the example in my brief is if somebody has appendicitis, you take out the appendix. It's isolated, it's clear, there's a remedy. And in those cases, a standard of care is required.
So my question was about the record testimony about Blyle not knowing what the state had or hadn't done to tackle the wrong way driver. That's certainly the argument that's presented as to the second half, right? I broke it down to standard of care and breaching it. What is your response to that part of the argument?
My response is the Dr. Blyle's position is that in the 10 years before this collision, there were 245 crashes with 91 deaths, and that ADOT took no additional measures during that period, and that was negligent. And the state's expert agrees that the state took no additional steps in those 10 years. Dr. Blyle identifies the steps the state had taken before that, which was wrong way signs and some other things, and he also identifies a number of things the state could have done. One specific approach would have been these TAPCO flashing warning signs. And there are studies that show that one particular countermeasure by itself reduces wrong-way crashes by 30%. And I think that one particular countermeasure by itself is probably adequate from a causation and loss of chance standpoint. So what Dr. Blyle was saying is, here's what they were doing. They were put on notice of a really bad problem, and they did nothing. And the negligence is doing nothing. And he also cites to the
So it's doing nothing. It's not doing a particular thing.
Correct. He says there were a number of options available, but importantly, he also says if you look at the state of California, they actually have a program to monitor wrong-way driving crashes, and one of Dr. Blyle's primary criticisms, as in the Glazer case, is that they don't even track wrong-way crashes. And until you track the crashes, you can't possibly know the extent of the problem and come up with a plan to deal with them. So what Dr. Blyle says is if you look at Caltrans, they've achieved well in excess of a 50% reduction in wrong-way crashes. I think in the record, 66% at one point, 75% at another point. But the point is they have clearly obtained a significant reduction in wrong-way crashes by taking a reasonable approach, which is a combination of measures, primarily including monitoring the crashes so you can know when and where they're happening. And the causation threshold is low under Arizona law, and as long as a reasonable jury could find that the state's conduct contributed to the outcome, there's causation. So Dr. Blyle, and he identifies 15 or 20 specific countermeasures that could have been taken. He relies on NHTSA, NTSB, AASHTO. I mean, the governmental agencies or the leading authorities in transportation engineering that discuss the problem. The NCHRP, we submitted Report 500 to the court. The NCHRP is the research arm for AASHTO. Yes, sir.
And so Dr. Blyle is well grounded in what the state has done or has not done.
We believe the record demonstrates that. He was well grounded in what the state had done, but more importantly, in what they didn't do in response to a glaring problem. And we also submitted evidence that the problem in Arizona is substantially worse than in other states. There's a study from the Illinois Department of Transportation, a very objective, unbiased entity, ranked the wrong-way driving problem by state, and Arizona was in the top tier, not adjusted for population. And if you adjust it for population, it probably puts Arizona in the top 2 or 3 states in the country for wrong-way driving problem, for the wrong-way driving problem, in accidents. So this is a real problem. And Dr. Blyle's opinion is that not only did they underreact, they didn't react. They didn't do anything. And doing nothing is negligent.
Did Dr. Blyle have any expertise in wrong-way driving or wrong-way drivers or what is going through these people's minds to the extent it's not chemically altered, and how to effectively, most efficiently, economically address that? Did he write any articles? Did he provide any other testimony?
No. Well, to answer the court's question, yes, he has experience. He had been involved in some wrong-way driving cases, and I believe when he worked for the Utah DOT, he did deal with some wrong-way driving cases. I don't recall precisely where in the record that is, but it's in the record. Has he published? No. But again, he was a senior administrator with the Utah Department of Transportation, and transportation departments often deal with these big picture operational issues. Folks, we have a problem, and we need to decide what to do about it. And we don't even know if ADOT got to the first part, which is, folks, we have a problem. So I would like to reserve 2 minutes for rebuttal. I would like to briefly also address 2 points. The trial court also precluded Dr. Bollhauer, our expert who has a PhD in warnings, and the trial court ruled that Dr. Bollhauer was not qualified to offer opinions on warnings. And the warnings issue is very important because it's part of ADOT, and we provided the testimony of a woman named Lisa Suplee who worked in the Traffic Operations Center. I took her deposition. ADOT has cameras that watches the freeways. She had seen multiple wrong-way crashes on prior instances, actually watched them happen, actually seen the collisions. And she testified that she saw wrong-way incursions 2 or 3 times a week. These are astounding numbers. And ADOT had created no standard message to give to drivers when a wrong-way driver appears on the video screens. And it's our position that that was negligent and not a rationed response. So the traffic operators had to talk and caucus and decide, gosh, what message do we display? They've got the big DMS overhead signs, and Brandon Mendoza passed underneath 2 of them on his way home, so it's likely he would have seen the message. And the message they put up, it may have said caution, it may not. We'll assume, to give the state the benefit of the doubt, that they said caution, oncoming traffic. The state doesn't have a warnings expert. And our warnings expert, who has a PhD in warnings, says that's inadequate because it lacks the 3 things that you need for a warning. You need either in this case, it should be danger, because your life is in danger. You need to identify the specific hazard, which is wrong-way driver, and you need to give people that are reading the warning instructions on what to do. This is a PhD in warnings, gives these opinions, it's clearly relevant, and the trial court rules he's not qualified to give warnings opinions.
Is a PhD in warnings for traffic, or is for medicine and things like that?
It's warnings more generally, Your Honor, but there's never been a suggestion that there are specific warnings that apply only to the driving situation. It's considered within the umbrella of warnings. And Dr. Bollhauer testified. It gave the opinion, if an appropriate warning had been given in this case, the collision would likely have been avoided. I mean, that's if you take the facts in the light most favorable to us, that is an ironclad causation opinion. This collision, yes, sir.
Okay, so let's look at those 3 situations. So we have warnings in a 12:30 at night on a driving on a freeway, a medicine bottle, and let's say slip and fall at Walmart. Doesn't the brain bring its own unique sort of bias and propensities to those situations? The medicine, you have a physician, presumably, who has authorized it, so you might not be as willing or eager to heed or read such warnings, and you're not likely to, versus a driver who you have other things going on. Aren't those at least somewhat different?
Yes, they are, and they're exactly the type of issues that a warnings expert, someone trained in human factors, should address. They are precisely the issues Dr. Bollhauer addressed, and the state didn't retain a warning expert to address those. And in light of all those issues and concerns, Dr. Bollhauer concluded if there's a proper warning in this case, the collision is avoided. So
it's fodder for cross-examination.
Exactly. Yes. So if I may, I'd like to reserve 2 minutes for rebuttal, and I've got about just over 2 minutes left, so I will go to my table at this point. Thank you.
May it please the court, Doug Northup representing the state of Arizona. The trial court had several independent reasons for granting summary judgment that this court can and should affirm on that are independent but all equally dispositive. First of all, whether or not the experts were excluded was not the grounds for granting summary judgment. The court said summary judgment would have been appropriate had she not even done that. I'm going to focus, as counsel has now abandoned any of the claims against DPS, on ADOT. The second reason...
So, counsel, would you agree with that we should look to the record and see if there's a question of fact without having to tackle the expert issue?
Well, no, because she did strike them. That is an abuse of discretion standard. And if she doesn't have experts, I think they've conceded as that expert testimony is required to establish a standard of care here. So I think the fact that she did strike them, but I'm happy to address, even if that happenstance had happened, there are not genuine issues of material fact. Plaintiffs did not make any attempt, as some of your questions recognize, to establish a standard of care here. And one of the things I do want to point out that's really important, Your Honor, what lawyers say is not evidence. I heard Mr. Leader say things just now, and I don't mean any disrespect to him, but are not in the record and are flatly wrong. And for that reason, we presented in the trial court and attached as charts 1 through 4 to our appendix specific admissions from the statements of fact, admitted facts, or the words of plaintiff's own experts, because it doesn't matter what I say the evidence is or what Mr. Leader says it is, it's what the witnesses said. And
Counsel, let me ask you, what was missing from Dr. Blyle's testimony that would have made it admissible?
Well, first of all, counsel, and I wrote down that Mr. Blyle's opinion was that the state did not act reasonably. That's a fundamental flaw throughout, because that states the duty. The Coburn case, specifically, the Arizona Supreme Court says the duty, if it exists, is always the same, to conform to the standard of reasonable conduct in light of the apparent risk. What the defendant must do or must not do is a question of the standard of conduct required to meet the duty. That's the key, and that's the reason summary judgment was appropriate, because an expert, and this is part of why Blyle was properly stricken, who simply says, you didn't act reasonably, is stating the duty. That's a legal conclusion. And when we asked Dr. Blyle specifically as to your question, Your Honor, okay, what was it that the state did or didn't do that it should or should not have done? And he said, I don't know. I didn't, he said specifically, there was no requirement to use any one of or a combination of these countermeasures, such as the TAPCO lights that counsel mentioned. Wasn't required at all in his opinion. That he had not done any analysis about what Arizona did or did not do with regard to wrong-way driver signage or detection before 2014. That's in the admitted facts that we've identified in the charts. He did not dispute in the record what ADOT had done. Retroreflective raised markers.
So what, to go back to my question, what precisely was missing from Dr. Blyle's testimony that would have made it admissible?
Well, there's a lot of things that would have had to be there, but for starters, he would have had to say, I have done an analysis to determine what the standard of conduct requires. And he admitted, I didn't do that. That wasn't part of what I did. So even if he had an opinion, and here again, it's not that he had an opinion that the countermeasures should have been used. He didn't go that far. He just said, oh, you didn't do enough. But the question would be, well, so how could a jury determine that's not just your opinion, but reflects a standard of conduct that if any Department of Transportation did not follow it, that would lead a jury to be able to conclude they weren't negligent. That would be one example. He hadn't done, counsel's talking about he relied on AASHTO and MUTCD. Mr. Blyle specifically said, I didn't do any analysis to determine whether any stretch of roadway met or didn't meet MUTCD or AASHTO or anything of the kind. I didn't even analyze that. And keeping in mind here, the standard for the state, we acknowledge the duty is to maintain reasonably safe roadways. This isn't a claim about not maintaining reasonably safe roadways. This claim is about the inability to stop the behavior of an extremely impaired driver who had 3 times the legal limit of alcohol in his system and methamphetamine. And it's not saying the roadway wasn't reasonably safe. It says you should have predicted the unpredictable and stopped, which in often cases is the unstoppable. And so that's a problem. They didn't even try to define the standard of care.
Implementing measures to see that people don't drive the wrong way is not an issue of keeping the roadway safe.
Information, Your Honor?
That the state failing that is preventing wrong way driving a part of keeping the roadway safe.
I think it can be, but then the question becomes, what's the standard of conduct? Is there one, and what is it? And did the state meet it or exceed it? Again, the state had, you'll notice if you're driving at night, if you look in your rearview mirror, all those markers on the roadway are reflecting red, right? Those have been out there for many years. When you pull on intersections like an exit ramp, do not enter, wrong way. Those are actually governed by METCD, and Dr. Belial admitted the state met those signage requirements. So, but what he was talking about is, well, some states have experimented with these flashing signs and various things like that, yet he specifically said, I don't know if they're required. I don't believe that any or all of them are required by the standard of care, but I didn't even do a standard of care analysis.
So, counsel, let me ask you another question. What was missing from Belial's qualifications that would have made his opinion admissible?
Here's a really important thing, Your Honor. Counsel is representing that Belial was excluded for reasons that he wasn't. The court didn't say he never could testify in a wrong-way driver case. The problem was he didn't have any experience that related in this case. The only thing he had done was read portions of a California Department of Transportation study, not even all of it. He didn't know who the authors were. He didn't know what the methodology was. When counsel says there was this large reduction in wrong-way driver incidents, that was comparing 2 years. And as we pointed out in our brief, if you compare other independent data points, you'd have a massive increase. So it wasn't that he could never testify. It was that he hadn't done anything in this case to be able to give relevant opinions. He simply said, you acted negligently, you acted unreasonably.
So we'll get to methodology in a second, but qualifications, the brain he brings into the room, the experience, what was missing? Articles?
Well, I think any relevant experience in dealing with wrong-way drivers and countermeasures, he could have cured that by study, evaluation, reading. I mean, but it wasn't that he could never testify based on his raw experience. It was that he hadn't done anything in this case to allow him to testify. And in fact, the opinions he rendered absolutely showed that he couldn't give the types of opinions that would even be helpful. And for example, on causation, Dr. Belial specifically admitted 50% of wrong-way drivers start out as going the right way. All of these countermeasures you've heard about are only relevant to a driver coming down the wrong way on an exit ramp. There are no known, according to Dr. Belial, measures for dealing with the driver once they're going the wrong way. He had no idea how or where the wrong-way driver here got going the wrong direction. He agreed, contrary to what Mr. Leader told you, and again, this is in the record and in those charts, he agreed that no countermeasure would have affected the outcome in this case, giving this driver's extreme level of intoxication. So it's not a matter of Dr. Belial could never, ever have been able to testify in a wrong-way case. It's just he can't come in, read snippets of a report that he doesn't even know who prepared it, and suddenly become an expert on that topic. The fact that he was giving legal conclusions. Again, counsel told you they want the opinion to be Dr. Belial didn't act reasonably. That's stating a legal conclusion.
So the Superior Court found he was not qualified as an expert on wrong-way driving, countermeasures, or standard of care, which was separate, I think, from the decision on unreliable because not the product of reliable principles and methods. The state's not challenging that first point, that he wasn't necessarily qualified, on wrong-way driving if he had done whatever reliable methods were required.
But potentially. But he had no more, he admitted Dr. Belial knew no more about wrong-way driving and countermeasures than any of us in this room who read the portions of the same report he did. He didn't apply any traffic engineering expertise or anything of the kind. He just read portions of one report, and that doesn't an expert make. And I think that's what the court was recognizing. And the idea that because the court said a trial court in the Glazer case didn't abuse its discretion in allowing Belial to testify is not a rubber stamp, that that expert can testify regardless of the topic as long as the state of the Arizona is the defendant. That's the problem. He didn't demonstrate that he had the expertise and experience and knowledge he had could translate to this case, this wrong-way driving case.
So, I want to clarify something in the record. Is it accurate to say that the state had no finite message crafted to go up on these boards when this was developing? That it was just sort of a creative, writing exercise. What should we put up, or was there something?
At the point in time this accident happened in 2014, as are many aspects of their job, the TOC operators were allowed to use their discretion, and they did. There's no dispute here that they came up with the warning, they posted it, they got it out there promptly. And one thing that's really important, no expert, Dr. Bollhauer did not opine about the conduct or reasonableness of the Traffic Operations Center personnel. His opinions were limited solely to the content of the message. So he doesn't have an opinion. They don't have anybody to say it is negligent or falls below some standard of care to allow your TOC operators to come up with signage any more than you don't tell a 911 operator every word they have to say.
Well, but isn't the focus on the driver? I mean, why does that matter? I mean, if the second doctor is explaining or testifying about the cognitive response, the synapse of a brain in response to a certain arrangement of words, aren't we concerned with the driver's brain rather than to assess negligence rather than the ADOT employee? And whether they, or isn't it the same thing? Doesn't the ADOT employee want to put up what will effectively discipline driving?
Well, of course, but I don't know if Your Honor is suggesting could a reasonable juror determine what was the right sign, because that's an issue that, first of all, Bollhauer said in his declaration challenging his exclusion, that these are things that are outside the normal juror's knowledge. Again, it's not a question of, it's what the content of the message was, but again, as an analogy, in a medical malpractice case involving warnings, you don't allow a juror to decide without expert testimony. Knowing what happened in this case, what warning would I have preferred? You have to say, another doctor has to say, what is the standard of care? And that's what's really critical here. Bollhauer, like Your Honor mentioned, he had no experience dealing with warnings to drivers. His warnings were in the product liability context, and they had done nothing to show that there was any similarity.
Well, because isn't that a matter for cross-examination that, yes, there are certainly differences between product liability and slip and fall warnings and warnings you would have to stop a runway driver, but they all discuss warnings, and it's all about how people respond to that. And would that just be, as the phrase we keep using, fodder for cross-examination?
Your Honor, if that's all there was, you probably would be right. But here's the problem. Their expert, Bollhauer, said, I didn't do a standard of care analysis, right? I think that I would have preferred a sign that said something different, and he analyzed the wrong sign to begin with, but that's really not even what's important here. He said, I don't know. The only thing I know about warnings on these DMS signs is I saw examples of 2 cities in Texas who had different warnings, not only from Arizona, but from each other. That doesn't set a standard of care. That just shows I prefer a different sign. Again, it has to be established from which a jury could say the standard of care requires certain content of a sign, and any Department of Transportation that doesn't do that is not acting reasonably. And we asked him, did you look at what are other states using on signs? Do they even have dynamic message signs? I have no idea, because I didn't undertake that kind of an analysis.
Well, is the state making that argument that we have dynamic messaging signs, and that's in and of itself sort of good enough? They're fortunate that we've made that investment, and just because we put these signs up doesn't mean we have to craft any particular message.
No. I mean, they put up the sign, right? And we wouldn't argue you could just say whatever you want. But if you're being sued for negligence, the plaintiff has to show the sign that was up does not meet some type of a recognized standard, so a jury isn't just left to speculate about is this an appropriate sign or not. And
where do you look for that standard? Other states?
Well, for example, generally, I mean, counsel mentioned that this particular one wouldn't be, but I mean, there are a lot of their AASHTO, NTSB, there's publications, there's statutes. I mean, we don't run red lights because the statute says don't do it. There can be authoritative treatises and studies. There's a body of law or information that an expert could potentially tap into, say, my opinion reflects a required standard of conduct. It's not just my opinion, but he didn't do that.
For this area.
Right. Well, I mean, there are studies and things like that. I didn't try to ascertain what should be the standard of care for signs or whatever as the defendant in this case when their expert said, I didn't even try to do that. And another thing that's really important, Mr. Bollhauer didn't say that, had there been a different sign, the outcome would have been different or whatever. What he specifically said, and again, this is in the record in those charts, when he was asked, do you think a different sign might have affected the outcome, his words were, a different sign, quote, could potentially change a driver's behavior. That is not probability. That is not a stamp from which a jury could determine more likely than not. He said, I don't have any idea, and we also don't know in this case where Brandon Mendoza got on the freeway, or whether he even...
just said his great cross-examination.
Well, but we don't even know. Again, the courts have said causation is generally a jury question, but the jury has to have evidence from which it could reasonably infer causation, and when you look at all of these things together, they couldn't. We don't even know whether he saw a dynamic message sign and whether it would have impacted him or not. This gentleman was a police officer.
You have to reach that issue, or is that...
Well, no, I don't think you need to reach it because their expert didn't attempt to establish... They didn't attempt to establish a standard of care or causation, and their expert said, part of the reason he was excluded, they didn't show any relevant experience in this particular case that would help show that he really is an expert. But again, when the expert doesn't attempt to say, here's a standard of care and here's why it's a standard of care, not just my opinion, and here's why the state breached it, but just said you didn't act reasonably. And I think with the benefit of hindsight and knowing what happened in this case, I would have done a sign differently. That is actually the opposite of having established a standard of care. So again, the judge is in, as Judge Howe noted, the judge is in the best position to evaluate the arguments. She made specific findings of fact and conclusions of law in excluding these experts. She didn't apply the wrong law. She said these opinions, they're not helpful, they're not relevant, they're not tied to the case. I mean, these experts haven't established an expertise that would be helpful to the jury, and that's an abuse of discretion. And the standard there is, unless this court concluded that no reasonable judge would have stricken this testimony, then that ruling should stand. And she did. She put a lot of work and effort into it. There were extensive motions for reconsideration. Other things that go to these experts, the reason they were stricken, or at least illustrates why, is two of the experts completely changed their testimony on the motion to reconsider. Blyle gave a declaration having said in his deposition, they did everything, I don't have any opinion these countermeasures were required, and said, oh no, these countermeasures are required. He went from saying, I have no idea, no reason to think a countermeasure would have changed the outcome, to saying, no, it would have. Bollhauer did the same thing. Robinson did the same thing, even though he's not relevant. So at the end of the day, Your Honors, there were multiple reasons why summary judgment should have been affirmed, should be affirmed here and was properly granted, independent of granting experts and including granting the experts. I'm happy to answer any other questions you have, but I would urge you to affirm the trial court in all respects.
Thank you, counsel. We appreciate your argument, counsel.
Thank you. I'll be brief. Counsel repeats the mistake he made in the trial court arguing standard of care. No standard of care is required. It is a concept that applies in limited professional negligence cases, not in cases against the government. The trial court accepted that proposition and based its rulings on the belief that a standard of care was required. It's not. It's a reasonable person standard, and all of Blyle's disclosures and all of Bollhauer's disclosures opine that the state was not reasonable. That's all we need to address. Counsel spent the majority of his time focusing on factual issues, and he has his 4 or 5 charts that highlight these factual issues. If the battleground becomes the facts, I think we have to win, because all reasonable inferences on summary judgment are construed in our favor, and I think at least 2 members of the court correctly recognized these are cross-examination points, and no more than that. Are they good, potentially effective cross-examination points? Maybe. That would be for a jury to decide. But for every point counsel raised about our experts, I could point to something in the record to counter it and to say our expert disagrees. These are factual issues. If they're factual, we win.
Well, what about, counsel, in your minute, why else was this summary judgment granted aside from, if there are others, these 3 exclusions and the lack of expert testimony?
Well, our last position is that even if you don't have experts, summary judgment was inappropriate. With 245 crashes, 91 deaths, and an admission by the state's expert, who's also a fact witness. Dr. Simpson is not just an expert. She's a fact witness who did factual research and work for ADOT. And it's our position that based on those facts alone, a jury could find the state did not react reasonably to the wrong-way driving problem, and Dr. Simpson could be cross-examined about Caltrans and the other states that have achieved substantial reductions in wrong-way fatalities by applying a reasonable combination of countermeasures. So, again, it's our position, and we briefed it, that even without experts, now we believe experts would be helpful in that they should be allowed to testify, but even without them, summary judgment should not have been granted. Thank you.
Thank you, counsel. We appreciate your arguments today. We'll take the matter under advisement and issue a decision in due course. We stand adjourned. Thank you.